Hello, everybody. Today is a great pleasure to host another FSI Insights, which is part of the online event series, which is dedicated to the theaters of top academic work in the field of energy regulation, energy policy, and today specifically also energy law. It's a key point. My name is Lucila, and together with Leonardo Meus, OFSI director, we host once a month the FSI Insights to discuss the work of these top academics in the field of energy and climate. For today, we have a great pleasure to host it for me, and I'm not being negligent with the words, one of the rising stars among the legal scholars, Professor Despoina Mantzari, who likes to be called Danny and tells a lot about her. So Danny is associate professor at UCL, University College of London. Her research combines doctrinal analysis with qualitative analysis, which is per se an important methodology when it comes to the legal scholarship. And her research has been founded by several research founds. Her work can be seen in the best peer-reviewed journals. And here she actually presented her last monography, and a very important one to the discussion of to legal scholars. The monography is entitled The Book, Courts, Regulators, and the Scrutiny of Economic Evidence, Comparative Perspectives, just published in the Oxford University Press in September of 2022. And to say, like, I don't want to anticipate what this point is going to present it here today and introduce the book, but I think two important words of the book, and especially for the audience of FSR. The first one is that the book challenged and tried to demystify one assumption, that is that courts, for being used to be generalists, are unqualified to review technical decisions of utility regulators. And here she does a very important quantitative analysis when it comes to the judicial review of regulatory decisions, regulators' decisions in energy, telecommunication, and water. And she does this with a methodology that is very important, a quantitative methodology, which is not common to see in legal scholars. And what she does is extremely important to validate her claim. And to be here and to discuss with Dennis on her book, we have a great pleasure also to have Adrien de Hauteclocque, which is our part-time professor at the Florence School of Regulation. And beside of this is the most qualified person from our team to comment on Dennis' book, because he's the head of cabinet of the president of the General Court of the European Union and non-governmental advisors to the French Competition Authority. And as usually we do, we try to bring together a senior person as a discussant and a junior person discussant. We have a great pleasure as well to host our PhD research from the law department, Selçukhan, Ünekbas, and I'm sure that I made some mistake in pronouncing your name, Selçukhan, but I will try to throughout it improve. Okay, so without further ado, I'm giving the floor to Danny. Danny, welcome to the FSI Insights, and we are looking very much to watch your presentation.
Thank you so much, Lucila, for this very kind invitation, and Adrian and Selçukhan for taking the time to engage with the argument of the book, to read the book, for being here today. And I very much look forward to a very fruitful exchange of views and discussion, and to learn from you and your perspectives. So I've been following, I've said, the work of the UI and the Florence School of Regulation very closely throughout the last decade, and I have contributed and worked, Lucila, with you, and on one occasion, I think, and it is a true pleasure of being here today. Let me share my screen. So I have a very short presentation. I will engage in a very short presentation of the book, so hopefully to allow time for comments and discussion that are more important in this endeavor. So the book is about courts, regulators, and the scrutiny of economic evidence. And one of the principal motives when I embarked on this book was to shed light on the challenges expert economic evidence and analysis presents for judicial review in a neighboring field to that of competition law. I'm a competition law, I teach in competition law, I write on various aspects of competition law, but I was interested in a neighboring field, that of utility regulation, that has been largely underexplored by both competition lawyers and administrative law scholars, because we see two different here communities writing on this field. So as with the case of competition law, the field of utility regulation has also been defined by the rise of economic expertise as an external source of wisdom and authority. Indeed, ever since the liberalization of essential services, technocracy has emerged as a rule by experts, but also as an ethos, as something like signaling the commitment to the protection of consumer interests through experts and expert economic evidence and analysis, whenever appropriate, by promoting competition. Professional economists have joined the agencies. They have, and in certain countries, as in the UK, the courts, they have applied their specific discipline-specific criteria in implementing the statutory goals and objectives. But unlike competition law, that until recently it was monocentric in nature, and we can debate this as well, the regulation of essential services has always been polycentric in terms of the plurality of economic and societal objectives it has to serve. It is there in the statutory objectives of the regulators. So as the book illustrates, economic evidence and analysis informs a very wide array of discretionary assessments. It informs also trade-offs between efficiency and equity, which have been more pronounced in the last 2 decades due to the broadening of regulatory objectives. Economic evidence is brought in to operationalize vague statutory standards like what is a just and reasonable price, and to give expression to trade-offs of the regulatory enterprise via its own tools, for example, welfare analysis. So when judges are asked to interpret the agency's statutory mandate, when judges engage in the process of saying what the law is, when engaging in statutory interpretation, or when they're presented with economic evidence in the courtroom, they inevitably face an epistemic asymmetry vis-a-vis the agencies, and this epistemic asymmetry may challenge the error correction function of judicial review. Judicial review serves many functions. I take the error correction function of judicial review as a focal point of the discussion. And this is something that a debate that we also have seen in the past in competition law. And you see when you turn to the literature, a bit of a more simplistic account, or it's too complex for judges, than like blanket deference, or let's educate judges in economics, or let's set up specialist courts and tribunals. And I thought that a more nuanced account of the interaction of judges and regulators with economic evidence in this specific field was missing from the literature. And I thought that epistemic asymmetry is not something that it exists or it does not exist. It is a matter of degree, and we need to shed light on various institutional factors that affect this epistemic asymmetry in order to be able to address more thoroughly and the error correction function of judicial review. So I thought that saying simply that economic evidence is too complicated for judges to grasp is not the end of the story, and we need to do a more nuanced and careful analysis. So I came up with the following research questions, the overarching one, whether this amount of economic evidence, the increased amount, challenges the error correction function of judicial review, that I develop in chapter 2 as judicial review serving both the thin and thick dimensions of legality. What are the limits of judicial review of economic evidence in appeals from utility regulators in the US and the UK? And this engage, I will explain in the methodology, a quantitative and qualitative analysis, and how should such limits be addressed from an institutional design perspective? Should we have generalist or specialist adjudicatory bodies, or some other sort of combination of legal and non-legal expertise? So when you look into the literature on this topic, there is a significant body of doctrinal analysis on judicial review of regulatory decisions, mostly done by administrative law scholars, but very little research that seeks to systematically examine the interaction of both regulators and courts with economic evidence. So the book aims to address this gap in the literature by engaging deeply with economics and by exploring for the first time their impact on the exercise of both regulatory discretion and judicial review into common law jurisdictions in the USA and the UK. So there's a lot of emphasis in Europe on constitutional and institutional dimensions of regulatory action, because this is dominated by the administrative law scholars. During my stay in the US at the University of Berkeley School of Law, almost all antitrust professors were also administrative law scholars. So you get a completely different engagement with regulatory agencies and what they do from both a field of antitrust and administrative law. And I also found that we never really actually learned directly how those that undertake regulatory tasks, the regulators, perceive their scope of decisional freedom relative to the statutory mandate, and what is the influence that economic evidence may or may not have on the reach and breadth of their discretion. So with the award of a British Academy Fund, I also interviewed regulators in the UK. So the aims is therefore to explore this influence of economic evidence and analysis, to identify and critique the limits as they arise in both generalist courts and specialist courts, and also to engage in a normative debate on what I call the sort of the substantive element, what is the appropriate scope of review, of judicial review, and the jurisprudential and the institutional dimension of the debate, what is the optimal institutional response to the pervasiveness of economic evidence in regulation. Method, it is a mixed methods approach, doctrinal, empirical, and the focal tool is comparative institutional analysis. So the book ranges over legal doctrine, judicial decisions, economic, social legal studies. This is not out of some methodological ambition I held. It is rather that the issue here of adjudicating economic evidence is a complex one. It depends on normative arguments we may have about which institution in the regulatory state, is it court, regulator, should have primary interpretive authority over defining these economically informed concepts upon which the enjoyment of essential services depends. And it also requires an understanding of how judicial and other institutions will respond to the demands of judicial review of economic evidence, how they perceive their role in the regulatory enterprise, and how this role evolves over time. So it is about actually regulatory discretion, but also judicial discretion, the interaction of the two, the limits, the constraints, and the intersection of two different rationalities, a legal rationality and an economic rationality. So to answer these questions, the book combines the theoretical, doctrinal, comparative, and empirical analysis, and it aspires to encourage a productive, therefore, dialogue between lawyers and economists, but also between administrative law scholars and competition law scholars who might have tended to talk past each other despite facing some common interpretive challenges. Now, the integration here of Neil Commissar's insights on imperfect alternatives on the appropriate scope of review of economic evidence invites us to assess the relative attributes of both agencies and courts, or in some other aspects, other adjudicatory bodies, say the CMA, the administrative law judge in the US, as well as the assessment of which of these institutions allows the broadest representation of interest before deciding on the appropriate degree of deference or the optimal adjudicative forum. So deference in the book emerges as an institutional choice between imperfect alternative decision makers. It reflects a judgment about which of the candidate institution, is it a court, is it an agency, is it a specialist tribunal, is best suited under the specific circumstances at hand when compared to other candidates to carry out the assessment of economic evidence enshrined into regulatory decisions. So the weight we give to these comparative institutional competence considerations that are analyzed in chapter 7 of the book, they're brought together actually in chapter 7 of the book, depends on several macro level factors that might be constitutional factors, but also micro level considerations, the court rules of procedure, its access to epistemic competence, and I provide a synthesis of these factors in chapter 7. The data set, a few words. I looked at the nature of the decision being appealed, the type of review, the outcome, remedy, whether it's a Court of Appeal decision, a Supreme Court decision, and here are the number of judgments that are being reviewed, and they are included in sort of annexes in the relevant chapters in the book. And the argument I pronounce in the book and hopefully defend in a persuasive fashion. The central argument is embedded in the case law of the US and the UK courts, following an analysis of the case law of these courts in the relevant chapters. And my argument has both descriptive and prescriptive components. I show that courts not only should, but for the most part, do adopt a modest and differential posture towards agencies' discretionary economic assessments. I find that recourse to economic evidence has, by large, transformed the scope, process, and intensity of review of regulatory decisions in both jurisdictions. In the US, we started from a very intrusive hard look review in the 1980s in the State Farm decision. And today we have a very undemanding version of rationality, thin rationality review, and I explain why. The UK, on the other hand, has seen an institutional response to the challenges posed by economic evidence, epitomized by the establishment of a specialist tribunal in the field of competition law and regulatory appeals. And at the same time, the introduction of statutory appeals has marginalized judicial review as a primary means to challenge regulatory agencies' decisions. What we see is the gradual rise of a complementary relationship between the judge and the regulatory agency. We don't see an institutional conflict, nor a state of blanket deference. It's not that they always defer to the expertise, but a measure of judicial restraint, a more incremental case-by-case approach that is predicated upon considerations of relative institutional competence. But this comparative institutional analysis I undertake does not only throw light on the allocation of decision-making competence across institutions, is it courts or regulators, but it also informs the institutional dilemmas. So I go and analyze the institutional alternatives that exist as regards the incorporation of economic expertise in the courtroom. Should we have specialist court vis-a-vis expert witnesses, assessors, court-appointed experts? And this analysis reveals that a specialist court enjoying both subject matter specialization and a combination of non-legal economic expertise could present the optimal solution for addressing the epistemic asymmetry that exists between the judge and the agency in regulatory disputes and could minimize the likelihood of error. How does this institutional claim interact with the normative proposals that are discussed in the book? Would we, for example, if we increase the epistemic diversity of the court, would this dilute the superiority of regulatory agencies when it comes to economic expertise? Yes, to a certain extent, save for polycentric disputes, like it might be access pricing, where even a specialist court will encounter the proper limits of adjudication. But a specialist court cannot substitute agencies' superior institutional legitimacy in policy considerations. I don't say we need to choose between the two claims altogether. The approach advanced in this argument is that we emphasize interinstitutional collaboration between courts and agencies that find themselves in an essentially complementary relationship in the regulatory space. And the optimal solution might require that a balance must be struck on which deference under certain circumstances is accorded to agencies on institutional competence grounds, and at the same time, some degree of epistemic diversity, and I will elaborate in the discussion later on why I believe this is important, is introduced in courts as an institutional foundation for economic expertise. So the contribution, I think it is for you to to judge, and for the readers of the book and the esteemed here discussants that I'm very fortunate to have today. I think it is the disciplinarity of the work that makes the book stand out, that it is a huge opportunity cost to engage and a huge risk, especially in the early stage of your career, to engage in interdisciplinary and empirical work. But it's something that is hopefully rewarded, an effort, an intellectual effort that is rewarded. Bringing together two fertile sources of scholarship that I found in the US. They were very much in conversation with each other, but not in Europe. Both the competition law and regulatory scholarship that informs the substantive rules of economic regulation, and the administrative law scholarship, which sheds light on the procedural rules governing this area, to engage deeply with the work of economists to develop a mutual understanding between the two disciplinary communities, and also to stimulate the dialogue between competition law, administrative law scholars, not only between lawyers and between competition lawyers and economists. So that is the end. That concludes my presentation. And yes, Lucila, I think the floor is yours to coordinate the.
Thank you so much, Despoina, for your presentation. It was exactly what we expected in terms of, I think for the audience, definitely you left like a flavor and a desire to read the book. And for the discussants of today, definitely like an extra inspiration besides reading the book to be the discussant. So thank you so much. And now, without further ado, I will pass the word to our first discussant, to Adrian, who certainly will have very insightful.
Thank you. Can you hear me, Lucila? Okay, we're good. So good afternoon all. I'm really happy to be with you here today and to be given the chance to comment a bit around the issues raised by Dennis' book, which I think is very well researched, interesting, interdisciplinary in its methodology, which is always very fruitful, and comparative. So in short, a very good piece of modern legal scholarship. I think it's also very timely. A few weeks back, the OECD published its guidelines for procedural fairness in competition proceedings. It argues there that effective judicial review is one of the most important aspects that make sure that parties' rights are adequately protected and that transparency is ensured. So no surprise there, I would agree, but I think it goes beyond that. First, it's not only in the realm of competition law that conclusion is relevant. I think it should apply to all complex regulatory proceedings. Also, it's not only about effective judicial review. It's also about the legitimacy of the entire system. In EU competition law, it's even a condition of legality of the system of administrative enforcement that we have following all the cases of the European Court of Human Rights and the Court of Justice of the European Union. But the world is changing. And the courts and the cases that we have on our docket are also changing. So judicial review must adapt, not only to stay effective, but also, I would submit, even to stay relevant in modern times. So let me now sketch out in broad terms two of the main challenges we are facing at the EU courts these days. First is increased complexity of the cases, not only in terms of the economics, it's also in terms of the science behind it. And for example, look at the chemical or all the science-based evidence that we have. So it's not only the economics. Look about the technology, the platform, the AI, the algorithms. It's also about the market designs. Look about the cases we have on energy. Honestly, are courts of law well equipped to take care of, to tackle this complexity? I think it's challenge number one. Challenge number two is the length of proceeding. How do we grapple with fast-moving markets? I think more than ever, justice delayed is justice denied. This is not only an issue for courts of law, it's also for regulatory and competition authorities. And I think some of the current developments For example, the ongoing revaluation of Regulation 1 2003, the ideas of the European Commission to take more decisions under Article 8 of Regulation 1, or also the DMA, the Digital Market Act. I think behind all this, there's also this issue of how do we stay relevant if everything is moving so fast, and if we are a bit too slow, are we still relevant concretely? So let me come back a bit to the first challenge. So how do we stay relevant in the face of increased complexity? So I think we can go about that issue through the question, sorry about that, through the angle of the standard of review. I think to stay relevant, what we need is to have the appropriate standard of review and then to implement it effectively. So at the EU level, I think now the standard of review is pretty clear. It's been pretty well defined over the years and has changed also over the years. So I think in administrative proceedings, there's a margin of discretion left to the administration, and this for good reasons, which are spelled out in the book perfectly. I think where there's still a doubt is on merger control. There we see it's not so clear, and the recent cases we will see, for example, CK Telecom, we will wait for decision of the Court of Justice. I think it's still in a state of flux. There's one very important area of the cases, which are the cases imposing sanctions. In particular, the big monetary sanctions, in particular, the big competition fines. And there it's clear since Intel in 2017, in the Intel case of the Court of Justice, we have to go towards full review and not marginal review. But then the problem is that we don't want that full review leads to maybe not arbitrariness, which I think this term is a bit loaded, but as I think at least a degree of judicial randomness. So how do we go about it? There were two avenues. The first is specialization of judges or their staff is one issue, specialization. The other ways to go about that, so which is to implement full review without falling into randomness, is to use experts. And this, I think, is one of the main challenges that we have. So it's how to best use parties experts, because of course in proceedings, the parties are used to come with experts. So we need to discuss how to best use them. So it's all about cross-examination or tubbing, or even asking them to come with a joint paper about, yeah, we agree to disagree, but what is it exactly that you are disagreeing on? So I think the use of party experts very important, but also should we have more our own experts internally or externally, so to appoint them. And this raises a lot of issue, in particular in terms of the length of proceedings, because at some point there's a trade-off between the two. We are thinking about this. This raises a lot of issues. I hope we will be able to implement that a bit more. Without falling also within not agency difference, but also expert difference, which I think might also be an issue. Just to finish, a few words on how to stay relevant, but time-wise. So more the issue of are we quick enough? We see that we are taking between 30 to 40, 45 months in the big economic cases. So that's already an issue, but sometimes it goes over 1 decade because you have this dual degree of jurisdiction. So you go in first instance, then you go to the Court of Justice, and then the judgment of the General Court gets quashed, and then it goes back down to the General Court, and this forever. So in the Intel case, for example, the contested decision was adopted in 2009, and we got the last judgment of the General Court in 2022, 13 years after, and now there's a new appeal to the Court of Justice. So of course, I think this reality, I mean, we have to think on it. So there are a lot of contributing factors, of course, the dual degree of jurisdiction, of course, the fact that these are sometimes gigantic cases and sometimes series of cases. For example, in the state aid area or in the cartel area, so you have a lot of cases in the same time. I think the length of proceedings is also a lot due to parties' behavior in the case. In particular, you can take into consideration the conjugation of all the interventions. The number of interveners is sometimes very spectacular in some of the big cases. Then you need to deal with these interventions, and then you have the issue of confidentiality, because of course the main parties to the case raise confidentiality issues towards each other or towards the interveners, and sometimes these confidentiality issues become case in a case. Almost, and it raises the length of proceedings tremendously. Of course, you have other issues like all the requests for extensions, for deadlines or from the parties, some diluting tactics, unfocused pleadings. So a lot it's on the behavior of the parties. And one last thing, it's the question of the length of decisions overall. Now, in the complex economic areas, in particular in competition law, it's not rare to have 1,000 pages decision. Then you have an application for annulment that is at least 400 pages. Then how do you want the court to come up with judgments of 50 pages? I mean, it's impossible. And so you have a sort of spiraling effect where the Court of Justice impose a duty to the general court to reason the judgments, and then the general court imposes also obligations on agencies and the European Commission to reason well the decision. And so there's a spiraling effect where in the end we are collectively responsible for this sort of, not madness, but I mean, it's complicated for everyone. So what has been done so far? So we had a huge problem with the length of proceedings. So basically we doubled the size of the general court over the last 5 years with the doubling of the number of judges. So this has helped us to bring down a bit the length of proceedings, to probably increase control, and to implement proactive case management. So now, as soon as a case gets in, we are accompanying the parties to the case. So it was good. We've also worked on internal guidelines to write clearer and shorter, because in the end, if nobody can read that, I mean, it's an issue. So what could still be done? And this is the main issue, because we said it's not satisfactory. So the specialization again. I mean, this is an issue. If you are specialized, maybe you're quicker. And so we have specialized the judges in 2 fields, so in IP and in civil service, but we haven't touched on the other areas of law. We have to know. So we'll see. Probably not competition or state aid, but maybe in some other areas. I mean, that would help, especially when the science is, and so the entry cost is very high. So that's one avenue maybe to improve. Another avenue would be the use of interim measures, because especially in complex economic proceedings, you might want to have the decision suspended when you disagree. I think we have a problem with the case law that is way too restrictive, probably at the moment. And the third is the issue of the expedited procedures that we have in our rules of procedures. So usually we only use them when the parties ask for it. But that would help a lot. And we have seen, for example, in the series of stated cases involving Ryanair lately, that the length of proceedings was only 10 to 12 months because we use this expedited procedure. So there you have only one stage of pleadings, and the case get priority treatment. So we might think that it could be, if we want to work on the issue of the length of proceeding, to have a bit more of these expedited procedures. So overall, excellent book. It was a real pleasure to look at it. Well, it was not the first time we discovered your work, obviously. But yeah, so I have two questions. I don't know, Lucila, if you want me to go at it now, or
go ahead. Perhaps you can address, Adrian, your 2 questions, and afterwards we move it to Selçukhan, and then we collected all questions, and then sure. Respond to them.
Sure. So actually, this is really in the line with what I was saying, and I'm very happy to hear what you could tell us about first about the role of experts. It's really something that is really topical and very, I think, important. So the main question is, how do you think we could make the most of parties' experts? So when they come with their own experts and their own expertise. And then should we appoint more now independent experts? So I think this is really one first question, open questions really, because I don't have an answer to this. And the second is really about the role of specialization of the judges, because I know you've worked a lot on that, and this is a lot in the book, because in the end, it seems that if you want to tackle complexity while also being quicker, I mean, well, there it might be a way to go. So what do you think? Is that the way? Is that the only way to solve that conundrum that we have? Thank you.
Thank you, Adrian. I think Danny, what Adrian, by speaking about the deference, the length of the procedures, length of the decisions, and length of the procedures as well, I think gives you just like a big nudge about to write it on the Court of Justice. Now is your next book. And perhaps because of the time, what I'm going to do to not reduce to give as well the satellites to Selçukhan, which is your junior law research of the law department, PhD research in the law department, which we're very pleasure to have you here, Selçukhan. So the floor is yours to address your questions, make your comments as you and know better than his work.
Thank you, Lucila. Thank you for the opportunity to comment on Denny's book. I agree with the previous comments because this book was really helpful and very nice to read. It really helped me learn a lot of new things. I'd like to highlight a few of the highlights of the book first, and then move on to 2 or 3 questions very briefly. First and foremost, I think the most striking and important part of this book for me was the great contribution of moving away from a binary understanding of the debate between regulators and courts. So as the book also acknowledges this, and I think this was the most valuable contribution, because so far in the entire literature and practical debate, what we have been hearing was courts are just very generalists, and they are thus unable to understand and act upon what regulators with specialist expertise have to say. So it was like a black box, and this deconstruction exercise has been very helpful, I think, because it's very important to understand in what cases some courts are not very well placed to understand, and in some cases, maybe they are not so much. So I really liked the mapping exercise in the book that tells us, we need to do a case-by-case analysis. In some cases, some courts, such as the Competition Appeals Tribunal in the UK, may be better placed to make some more intrusive judgments. So this moving away from this binary attitude towards more legal realist approach has been very helpful for my own research as well. That's my first comment. And secondly, I think the book also contributes to this broader debate about courts versus legislatures or courts versus regulators. So I think it's a very welcome development there as well. And while the book actually talks about utility regulation and not necessarily competition law, which is what I'm working on, I think it still has a great potential to have spillover effects on other areas of law, especially competition law and especially other types of regulation. I mean, Adrien talked about the Digital Markets Act, and that is very much inspired by utility style regulation and also competition law. So it constitutes a really fertile ground, I think, for the application of this book. So it is also very timely. Another aspect that highlights why this book is timely is because economics itself is very much sort of, let's say, under attack recently. economic evidence in court proceedings, especially in some fields like competition law, is under attack as being either outdated or excessively or mistakenly scientific, let's say. So I think what the book does best is, firstly, it shows that economic evidence in utility regulation or competition law is more than graphs and models. So I think that's a great contribution. And secondly, it also shows that economic evidence is not only about maximizing efficiency. So I think it breaks down these two myths and also shows that economic evidence helps courts navigate the ambiguity of legal rules. So I especially liked, for example, the argument that economic evidence really helps narrow down the widely constructed nature of legal rules. So I think that was a very valuable point as well. And from that, I would like to jump a little bit towards the comments also made by Adrian and talk about the length of proceedings and how economic evidence touches upon that. I also agree that staying relevant and maybe expediting the processes in utility regulation, competition law is very important, especially in today's age. At the same time, in the book, one key area where judicial review can help and provide added value.
I'm really sorry. I've lost you for a minute, and because my Zoom crashed. But it was in discretion. They narrow down and the confines. It structures discretion. This is where I was left. Yes.
Okay. No worries.
I was the signal in the office. Yeah.
Yeah. I was talking about staying relevant and how expediting the court processes can help in today's economy. In one part of the book, we talked about how courts can provide added value by reviewing regulatory decisions in terms of their thick legality. So how they conform with, let's say, procedural rights or other broader legality review. And here we can talk about some recent case law and contrast the need to become very fast and the need to respect fundamental rights. And here, for example, we see a very recent case in Qualcomm where it was a competition law case where the General Court actually annulled Commission's decision in its entirety. And this is a very, very rare phenomenon, especially it was an Article 102 case. So one of the reasons for this annulment was the Commission's lack of respect for fundamental rights of defense. So this case, very recent case, teaches us that fundamental rights and rights of defense are very important. And when we take a look at the elephant in the room, the utility style regulation of the Digital Markets Act, we see that the European Commission has recently released a document, an implementing regulation draft, which is, to put it lightly, very unfortunate for would-be gatekeepers because it prescribes page limits for defense memorandums, and you have 30 to 60 days to present your reasoned opinions to rebut the Commission's claims, and the Commission is not subject to these limitations. So there's clearly an imbalance of the strength here. So what I'm trying to say is procedural rights and rights of defense, which were underlined in very recent case law, are kind of jeopardized by in the realm of utility regulation, let's say. And would you think, and this also doubles as a question, would you think that this constitutes a problem? And especially given the fact that the Commission will have lower chances to learn, what do you think about the outcome of this development? That can be my first question. And I would have one more question to ask, and that is, when I started reading the book, Courts, Regulators, and Economic Evidence, the first thing that came to my mind was the phrase complex economic assessments. And this has actually, in the past, this has featured a lot in EU case law, with the whole modernization and more economic approach debate. But right now, I fail to observe this. So there's no mention of complex economic assessments. I mean, of course, the courts touch upon this by their review of Commission's decisions, but they do not touch upon this explicitly. They sort of push this aside and try to wait it out so that it goes away. So what would you think about this complex economic assessments debate? Thank you very much again for this opportunity.
Thank you, Selçukhan, for the great comments. I think it's a matter of as well for you, Selçukhan. I think it's a great, and make some advertisement here. Perhaps you have already a great case for writing a book review on the European Journal of Legal Studies. And now I just pass the hot potato for you, Danny. To answer the questions, we still have we have around the 13 minutes. So feel free to answer and address the questions if you still have some time to take questions from the audience. We don't have yet, but I will leave this to the end if you have it. Go ahead.
So thank you very much. And I think, Adrien, you have a very, very thorough, and I'm very, very privileged to learn from you, given your current affiliation. I'm very, very privileged for you providing me this overview of where you stand at the court and the debates that take place and how to solve this conundrum between ensuring upholding the rule of law in a timely and efficient fashion. And I think, for me, efficiency is important, and timely resolution to a dispute is something that is very, very, very important. Justice delayed is justice denied, and we've seen this with Intel, and we don't want to have a decision when all the competitors will have, by the time the decision is out, have exited the market, and all we're faced is dead bodies. But it's also important to uphold the thick and the thin dimensions of legality. And I struggle, I understand very much the struggle of providing a timely resolution and also a fair resolution to the dispute. And there are various tools. For me, the standard review is important, but procedural rules that are in place are more important and may render a standard review as sort of a label. So to give you an example from the UK, when after many, many years of sort of lobbying, Ofcom managed to change the standard of review before the Court of the Competition Appeal Tribunal to judicial review, from a merits review to a judicial review standard. But because the court is specialist and specialized, and because of its rules of procedure, it is still able to do a more searching judicial review, right? It cannot substitute, of course, its decision as it would do under the merits review for that of the primary decision making, but because of its subject matter expertise, its specialization, and the court's rules of procedure, it is able to provide a more thorough review under a judicial review standard. So for me, it is just the label, and it all boils down to who is present at the court and the court's rules of procedure. And you mentioned about case management that I think is important, active case management through active intervention in order to render a more timely resolution to the dispute. It is this also dilemma on whether you rely on experts and the neutral, whether courts should use neutral expert evidence that is obtained through an expert report that is commissioned by the court, or should they use partisan expert evidence that is voluntarily submitted by the parties. And it is a question to me why the courts, have not used, the EU courts have not used neutral expert evidence more frequently, and that is something that perhaps needs some rethinking, but clear, perhaps procedural rules. It is always a mystery to me why we don't see neutral expert evidence that often, and I think that combining, I'm not saying bringing, render the court an economic sort of, an economic court as such, but providing some non-legal expertise together with subject matter specialization can enable a more sort of dialectic relationship between this legal and economic rationalities to develop and flourish, because you don't want a court to be captured, a generalist court to be captured by a prevailing view in economics, right, or by a certain school of thought. You want to ensure this sort of plurality of theory and that exists in the economic world and the economic rationalities. You don't want a single economic rationality to prevail, I think, in the court. So I think recent theoretical work I was looking at in decision-making theory and the law generally is in favor of the epistemic benefits of cognitive diversity in the courts. And it's not only about competition law, but even in the studies done for the US Supreme Court, that it should be a bit more diverse. And a court which has at least, these studies show, at least some lay justices can minimize judicial error across a total number of cases compared to a court with 0 lay justices in areas where the law draws upon non-legal specialized knowledge, be that scientific expertise or economic expertise. And also for me, it avoids a situation of what Adrien Vermeulen calls an epistemic bottleneck. So when you have only a small group of judges trained in law deciding whether they should turn to an expert and how to incorporate non-legal expertise, you have an epistemic bottleneck in place, right? Whereas having some lay justices may allow for more deliberation to happen when the court is forming its judgment and it's offering an opinion on the case. Also, a court that is specialist may be able to more effectively and quickly, if we care also about the timeliness, cross-examine witnesses, and it can, I think, more easily expose misleading and vexatious elements in the proceedings more effectively. So this would ensure that in adversarial proceedings where both parties offer meritorious interpretations, as it happens in economic evidence of factual and legal and economic circumstances, the party which has a more complex model or the most sophisticated analysis will not necessarily have a better chance of winning the case simply because it has resorted to this technical wizardry. So I think procedural innovations such as hot tubbing can deliver more promise also in the context of a specialist court, because this process of hot tubbing requires the court to take the lead role in questioning the expert witnesses, and this naturally requires the court to have a good grasp about expert witnesses' testimony and the differences that they had on what they have agreed to disagree. So it can, I think, solve this conundrum. I would think active case management, innovation, procedural innovation, that's hot tubbing, and then it is a comparative, again, institutional analysis, whether these procedural innovations would work better with before a generalist court, as the courts of the European Union, the Court of Justice of the European Union, the General Court, or whether these innovations, procedural innovations, would hold greater promise and deliver quicker and better results in the case of a specialist court. For me, it is about maintaining a dialectical relationship on the bench, not only amongst the expert, the parties and the judges, but having this dialectical relationship on the bench that will enable also some sort of second guessing, perhaps by an economist, of certain facts that are presented in the dispute or certain analysis, and sort of make this sort of epistemic bottleneck sort of somehow be diminished in relevance, which exists, I think, when the court is composed of generalists. But yes, that would be that would be brave, I think, a brave move. And it would, even in the UK, the Competition Appeal Tribunal, that is, well, it started with a restrictive trade practices court, and it's now the Competition Appeal Tribunal. It has a long history, and still it is something that, you know, that is its reputation may be sometimes under attack because of a firm belief that unjustified, I think, in this case, of the fact that the judge ought to be generalist. It's not about having the bench be composed by economists, but introducing epistemic diversity on the bench. That is, for me, important. I think I became very passionate about this, and I have only 3 minutes to address the question. So on Qualcomm, yes, procedural fairness is important. So we've gone away. I see the doctrine of complex economic assessments and manifest error of assessment has actually, in public economic assessment, has disappeared from recent case law on abuse of dominance positions. It is no longer there, and it is, I think it merits an article of its own of why this has disappeared, why this judge-made, it is a judge-made, right, the standard of review has disappeared from the case law. It is, I think what we see here is a proceduralization. So instead of engaging with how the as efficient competitor test was performed, that might be best left, for example, to experts. The court engages with the way it was performed in the sense of who had the opportunity to offer, who had the opportunity to offer its input and defense, or the right here of defense in this case on Qualcomm. And here I think we see a focus very much on thick, or what I call in the book, on thick legality. So I think the court here is enforcing procedural rights to perhaps render the decision-making process of the European Commission more transparent, to make sure that the various views here have been considered. And I think this is where the court's role is very important. Is this an abdication? Does this show a sort of an abdication in part of the general court of its intention to review the nuts and bolts of the as efficient competitor test? I don't think so. I think it's actually upholding here the thick legality consideration. And I think this is where the courts, the procedural rights, offer great also promise in presenting a range of tools that courts can use to bring the benefit of affected parties' participation in these disputes, and especially in polycentric disputes. So ensuring reasonable access to information, mandatory consideration of an interest or a fact or a duty of consultation, and right to be provided with reasons. All these are part of the thick legality, not the thin legality of how the test, of what the test actually showed, the as efficient competitor test, but how the test was performed. I think the test is, I have an article on the as efficient competitor test, and I think it's relevant as a framework of analysis. And here also I think the court has created a sort of a duty of the European Commission to perform a test through the back door, by actually saying that when the defendant brings forward an as efficient competitor test, you need to engage with it thoroughly. So on the one hand, you don't need to perform your own as efficient competitor tests, but when it is presented in litigation or during the decision-making process, you need to engage. So this is actually the way that judges try to remain, I think, relevant in this space that becomes more complex, economic, and technocratic, by upholding the rule of law and the thick, like ensuring the decisions thick legality. That is my understanding of Qualcomm. DMA and the future. Yes, I need to look at these I have to confess, I've not read the implementing here guidance, but I like very much your point on the learning curve, that this is a learning curve. This is something that is untested, it is new, and perhaps, yes, 30 to 60 days is this sort of imbalance in procedural rights between the parties and the Commission will not allow for the community, for this specific community to learn. And it's something, a very important comment that I must confess, I need to think a bit deeper on this. On generally, I like very much the fact that you mentioned the relevance in the future on the DMA, and I think we see more complexity now. We have a lot of literature on complexity, economics. We also have new disciplinary communities coming in from data science and computer science. So we have new types of evidence that will enter the courtroom. So for me, the important thing is to ensure we have the procedural rights for this sort of knowledge that exists, right, in the professional world, in the outside world, to be able to enter the courtroom in a meaningful way, and to sort of break out and bundle sort of this epistemic bottleneck that that only those who have legal expertise will decide about when and how to incorporate economic evidence. For me, this was an eye sort of opening moment when I was writing the conclusions of the book, of who actually decides how and who we are going to invite, when we're going to invite, how we're going to listen to extra legal, extrajudicial sources of evidence. That was the important consideration. And we'll see new sources of wisdom coming in from data science and computer science, and perhaps complexity that I know you're working at the EUI might offer a new theoretical lens to look at essential services as complex systems, and perhaps industrial organization economics won't be, will have their dominant sort of position threatened in the future. That makes, again, my argument about not having the court captured by a particular school of thought, of method and analysis important. That's why we need, I think, more epistemic diversity in our courts, especially in areas where the knowledge can be contested and source of wisdom. And finally, yes, value judgments. I think economics are extremely important, especially when they offer the so-called welfare analysis. If I increase mobile termination rates by 0.1, and how will this impact innovation, parties, in existing players in the market? And I think the economists might lose the game when they make the value judgments themselves. So that is, I think, another contribution of chapter 4. It enroaches upon issues of institutional legitimacy that are important.
Okay. Danny, I think the FSI
answer, yes, I would very much value. I will write to Adrian and Selçukhan also this conversation by email.
It's nice of you. I would like just to conclude to say that FSI Insights 1 hour, it's not enough to cover like the values that your book is bringing. It's too short, so it's pages to come, and definitely we have a lot of discussion. Thank you for presenting and so nicely respond to questions, and thank you, Adrian and Selçukhan, for reading the book and raising also so important points in this. I'm sure we will see you many times, Danny, at FSI, at the UI.
Thank you very much. Thank you for this kind invitation and for engaging with the book and giving your precious time for this discussion. And I've learned a lot from both our written correspondence and our discussion here today. And I look forward to more discussions without time constraints in the near future. Thank you very much. Thank you, Lucila, for the invitation and for hosting, and to the team at the EUI FSR for having me.